Good afternoon, my lord. My name is McCann and I appear for the pursuers in this case, Hard-Wearing Surfaces Limited. My lord, before I continue with my submissions, does your lordship have sight of all relevant documents such as the list of authorities, list of productions, closed record, counterclaim and the Rule 22 note? Thank you. My lord, the case at hand is fairly simple. There has been a series of contracts and a course of dealings between the defender and the pursuer. The pursuer has supplied the goods in accordance with each individual contract under condescendence 2. The defender has admitted that they are refusing payment under condescendence 3, pending the outcome of their counterclaim under condescendence 2. The law in relation to this case is one of the right of retention, damages and mutuality. These will be addressed in turn. The format will, however, follow that of the order of the list of authorities. McBride outlines at paragraph 2062 that retention is to withhold performance of a contract. This should not be confused with compensation of debts. Compensation of debts being that payment is withheld. Liquid debts can be set against each other, but illiquid debts cannot. In a mutual contract, performance may be withheld due to the mutuality principle. The mutuality principle applies to all contracts, hence a claim for sums due may be met by the defence of the defender that they have claims arising from the pursuer's failure to fulfil the contract. This is outlined by McBride in paragraph 2067. McBride further highlights the disadvantages of claiming damages when damages are illiquid. This is at paragraph 1463. An illiquid claim can be pleaded, answered in relation to a liquid claim. However, this does not require a counterclaim. A counterclaim also does not need to offset the initial claim to be competent. The opinion of Lord Drummond Young in the Purac Limited case summarises the right of retention features at paragraph 10. The first being that the right only arises if the two obligations are counterparts of each other. Secondly, the right only arises when one party is in material breach of the contract. Thirdly, the function of the right of retention is to provide a party to a contract with a form of security by the other party of its outstanding obligations. Fourthly, the right of retention may apply to building contracts. Lord Drummond Young expands upon the materiality of the breach, such as if the breach threatens the future performance of the contract, or if it deprives the innocent party of a substantial benefit to the contract. A distinction, however, is drawn, these being that misperformance or defects in performance will not always constitute a material breach of a contract. In the Barton case, Lord Osborne gives his judgment and addresses the right of retention and mutuality principle. My lord, it is noted that this case is similar to the case at hand. In regard to the right of retention, Lord Osborne outlines it is insufficient to show only a course of dealings between the parties. It has to be demonstrated that there was a particular degree of connection between the contracts. This would have to be obtained in order to see the several contracts as one singular contract. Lord Osborne makes reference to a judgment by Lord McDale and states that for the right of retention between illiquid and liquid claims, These must arise out of one singular contract. Lord Osborne also references Gloag and Irvine. These outlined the 4 exceptions to the right of retention rules. The first exception being where the illiquid claim admitted of instant verification. 2. Where the liquid and illiquid claim arose out of the same mutual contract, this being the mutuality principle yet again. 3. Where one or other of the parties were bankrupt. 4. Where in exceptional circumstances retention had been allowed to meet justice or convenience of this particular case. Lord Osborne further held that mutuality could be extended to apply to 2 or more separate contracts. This is where parties would have agreed so. Reference was made to a judgment by Lord Cameron that stated if there is a series of transactions between the parties and each transaction or series of transactions or group represents a separate contract, then a counterclaim can only be competently pleaded against claims for payment in respect that each transaction or series of transactions. An exception to the mutuality principle was also referenced, in that a debt which is admittedly due and payable cannot be withheld on the plea of retention in respect of a claim for damages which does not directly arise out of the same contract. The more recent Supreme Court case in Varesk, and particularly the judgment of Lord Hope, reiterated and relied upon the aforementioned Purack and Barton cases and reiterated the points made previously. Applying the case law to the current facts may be quite complex. It is, however, worth stating, my lord, that each order was individual. They were all ordered at different times. Whilst there may be a course of dealing, each contract was not reliant on the previous or next contract being fulfilled. They were all independent of each other. This is highlighted by production number 8. This is a quote for goods that were purchased and supplied but did not depend on the previous sales, those productions being numbers 1 to 7. These were initially contracted and supplied, with payment still being withheld. Pursuer's productions 9, 10, 12 and 13 were also supplied with payment being withheld. This is also the case for production number 11. However, production number 11 is the subject issue of the counterclaim, one individual invoice for the whole counterclaim and withhold of payment. Applying the Barton case, a course of dealings does not allow for the right of retention. It has to be shown that there is a connection between the contracts in order for these contracts to be seen as one whole contract. As outlined, each individual order was separate and did not rely on another being fulfilled. This highlights that they were indeed individual, and hence there cannot be a right of retention. Given that the case at hand is one of illiquid and liquid claims, the singular contract is imperative. It must be seen as one singular contract in order for the right of retention to be utilised, and this is rejected at this current point. The 4 exceptions of the standard right of retention rules shall be addressed in turn. The idea of instant verification is rejected. The goods were supplied at the craved price for several sites. One site cannot constitute double the sum craved for several goods delivered. It is submitted that this is excessive, and this is not normal practice. The invoices provided by the pursuers was calculated at the standard work for that job and in accordance with the supply and demand price at the time. The mutuality principle is also rejected. Whilst there is a series of similar transactions, these do not form one continuous contract as previously stated. Further, this principle cannot be relied upon where the debt is admitted, such as has already been admitted by the defender under Condescendence 3 and 2. In relation to the third exception, that being the bankruptcy exception, this is also rejected. No party at the time of this hearing or at the time of the contract being formed was bankrupt. The fourth exception is that of judicial and equitable discretion. It would not be just nor equitable to allow this exception, as the goods have been ordered, they have been supplied, and this has all been to the specification of the order. And due to this, the pursuer is entitled to payment under standard contract law. In relation to the Purack case, a defect does not constitute a breach of a contract. The pursuer should have had the opportunity to remedy the defect, but was given no such opportunity. This is unjust. As such, the pursuer should be entitled to payment for not being made aware of the defect, nor be given the opportunity to amend the defect. To summarise, the defender is withholding payment for several individual invoices and contracts. The pursuer supplied the goods in accordance with each individual order and to the appropriate specification of the order. The defender is withholding due to an issue with one order, which is not in accordance with the case law as outlined. The pursuer is entitled to payment as an illiquid claim cannot be withheld in this instance as outlined. The defender's case lacks specification in relation to the claim. The sum, therefore, is due to the pursuers. The counterclaim at this point is irrelevant and should be treated separately in this matter. My Lord, it is craved that the court find in favour of the pursuer for the sum sued. It is also craved that the court find the defender liable for all expenses. In relation to the counterclaim, we ask that the court fix a proof before answer and treat this matter separately. If your Lordship is not with me on the sum sued, it is requested that decree is granted for £39,600 sterling, which is the sum craved minus the production 11. Production 11 being the subject of the counterclaim, and we ask that your Lordship fix a further proof in relation to this matter in order to come to the crux of the issue and lay evidence appropriately before you. It is still requested that the court fix a proof before answer in relation to the counterclaim. If I can be of no further assistance to your Lordship, that concludes my submissions. Thank you.